He pulls out that gun, he aims it, he shoots Randy not just once, he shoots multiple times.
Toss one's own child into a dumpster like trash.
Is that Lana Clarkson killed herself while she had her purse on her shoulder. They couldn't show that she had suicidal ideation.
Ben Oliver was sentenced for the unlawful killing of his 74-year-old grandfather, David Oliver. At the time of the offense, Ben was 23 years old at that time.
Ben Oliver, you are here today to be sentenced for the unlawful killing of your 74-year-old grandfather, David Oliver. You were 23 when you carried out the killing and are now aged 25. On the 14th of January of this year, you pleaded guilty to manslaughter on the grounds of diminished responsibility. You were tried and acquitted of murder by a jury on the 25th of May.
He pleaded guilty to manslaughter on the grounds of diminished responsibility, and a jury subsequently acquitted him of murder.
The sentence I pass upon you is therefore one of life imprisonment with a minimum term of 10 years and 8 months. From that term will be deducted the term you have spent on remand, which is 553 days. That deduction results in a term of 9 years and 63 days. Those numbers can be amended administratively if my calculation is incorrect. Once you have served that term, you will be entitled to apply for parole. However, you will not be released by the parole board unless they conclude that you no longer pose a risk to the public.
The judge sentenced Ben to life imprisonment with a minimum term of 10 years and 8 months. Factoring in the 553 days he had already spent in custody, his remaining sentence was reduced to 9 years and 63 days. After serving this term, Ben will be eligible to apply for parole. However, his release will depend on the parole board concluding that he no longer poses a risk to the public. Daha Hassan's sentencing stemmed from a tragic road rage incident in Minneapolis along West River Parkway. The events unfolded one evening when Hassan and Randy Burris, a 34-year-old father, became involved in a confrontation. Burris, who was recovering from prior injuries and wearing a visible neck brace, was unarmed during the encounter. As tensions escalated, Hassan fired a homemade firearm from his vehicle, resulting in Burris's death. Prosecutors later emphasized Burris's vulnerability due to his injuries and argued that the situation did not warrant such an extreme response.
Without any sort of warning, any sort of, I have this gun, back up or I will use it, he pulls out that gun, he aims it at Randy Burris, and from very close range, within a couple of feet away, he shoots Randy not just once, he shoots multiple times.
Following the incident, Hassan claimed he acted in self-defense, suggesting Burris had escalated the altercation. However, evidence presented during the trial, including body camera footage, contradicted his account. The jury found Hassan guilty of unintentional second-degree murder, rejecting his claims of self-defense. At his trial, Hassan expressed remorse for his actions, apologizing to Burris's family. In court, he stated he never intended to harm anyone.
I never wanted to kill anyone, ever, in my life. Never wanted to hurt anyone ever in my life, and this is really hard for me. And I wanted to say, if it wasn't clear before too, that I'm sorry to the family.
Despite his apology, the court acknowledged the gravity of his actions and the impact on Burris's family. During sentencing, the judge imposed a 13.5-year prison term, of which Hassan is expected to serve about 8 years in prison, followed by supervised release. Prosecutors sought a longer sentence, citing the unarmed and vulnerable state of the victim, but the court adhered to the guidelines for the charge. 2 Canadian men, Devin Wolfgang Vanderhoff and Darius Avery White, were arrested in Monterey County, California, following an alarming incident tied to an online connection. Vanderhoff had developed an unhealthy obsession with a woman he had met through years of online gaming, leading to a troubling chain of events. On November 25th, Vanderhoff and White traveled from Canada to Salinas, California, with a plan to target the woman.
For somebody to have flown from Canada down to this part of California to commit this type of heinous act is definitely unheard of. Mr. Vanderhoff posed as a delivery driver. He was carrying a box and knocked on the door to this residence. The door was opened by our victim's boyfriend, and when the door was open, Mr. Vanderhoff forced his way in and immediately began stabbing the victim's boyfriend.
Disguised as a delivery driver, Vanderhoff approached the woman's home carrying a box containing handcuffs, duct tape, and knives. When the woman's boyfriend answered the door, Vanderhoff forced his way inside and attacked him. A struggle ensued as the woman intervened to protect her boyfriend, and all three were injured during the altercation. Fortunately, the victims survived the ordeal. Authorities responded quickly to the scene, arresting Vanderhoff on site. White, who had accompanied Vanderhoff on the trip, was arrested the following day at San Jose Mineta International Airport while attempting to return to Canada. Both men face charges, including attempted murder and conspiracy to commit a crime. Bail was set at $4.15 million for Vanderhoof and $1 million for White. They have both pleaded not guilty.
It is just so undescribable, so unusual, so bizarre to see something like this develop.
The Monterey County District Attorney described the case as one of the most unusual he had encountered, expressing relief that the situation did not escalate further.
It's pretty strange. I think the community was, let's just say, shocked. I don't think people really know what to really think about this. I think it shows you, if anything else, that you really have to be careful what you do online.
The incident serves as a stark reminder of the potential dangers of online interactions and underscores the importance of exercising caution when engaging with people met through the internet. As the victims recover, Vanderhoof and White remain in custody while legal proceedings continue. In 2014, Michael Todd Hilton, a 34-year-old with a history of 6 prior DUIs, drove under the influence in Hardin County, Kentucky. While intoxicated, he ran a stop sign on Patriot Parkway, colliding with a car driven by Breonna Taylor. Her passenger and best friend, Michaela Herrig, sustained life-altering injuries. During the trial, prosecutors argued that Hilton's actions were reckless and showed wanton disregard for the safety of others. During closing arguments, the defense sought to minimize Michael Hilton's intent, portraying his actions as less severe than the prosecution argued.
You may find that he drove recklessly. That means that he is guilty of reckless homicide. You may find that he is guilty of driving wantonly. That would mean he's guilty of second-degree manslaughter. Either way, he will be held responsible in this case. Either way, he will not be getting off.
Michael Todd Hilton turned this day full of immense promise into an everlasting nightmare. That night, the actions and decisions that he made took Breonna Taylor off this earth, permanently injured Michaela Herrig, and even almost killed his own brother.
However, prosecutors firmly countered by presenting the jury with various potential convictions. They assured the court that Hilton would be held accountable for his choices. In 2015, Hilton was found guilty of murder, first-degree assault, second-degree assault, and DUI. The jury recommended a life sentence, which the judge imposed. In 2020, Hilton appealed his conviction, alleging ineffective assistance of counsel. However, the Kentucky Court of Appeals upheld the original conviction and life sentence, rejecting his claims and affirming the accountability established during the trial. In December 2018, a tragic road rage incident on the Belt Parkway claimed the life of off-duty FDNY firefighter Faisal Cotto. The incident followed a minor crash. Cotto, 33, was known as a kind and selfless man who served his community with dedication and bravery. Joseph Desmond, the individual charged in the case, was accused of assaulting Cotto and leaving him injured by the roadside without seeking help.
Not only did he assault him and injure him, but he left him lying on the side of the road without calling for help, calling for assistance. That was a true mark of cowardice.
Despite the evidence presented, Desmond disputed the charges and showed no remorse for his actions. During the trial, Faisal Cotto's family members shared their grief and the enduring pain caused by the loss of their loved one. Cotto's brother addressed the court directly, highlighting the devastating impact of his death on their family.
Since December 9, 2018, it has been a struggle to live in a world without my brother.
Their mother was seen wiping away tears as she listened to the heartfelt tributes to her son's kind and generous spirit.
Today he turned 33 years old. And that's the same age my brother was when he took his life. Faisal was an amazing soul.
Andrew Ansbro, representing the Uniformed Firefighter Association, described Faisal as an invaluable asset to his family, friends, and fellow firefighters, leaving a lasting legacy through his kindness and dedication.
Faisal Carter was a great and selfless man, loved by all that knew him, an asset to his family, his friends, and fellow firefighters, and assets in New York City. His loss is a loss to all of us.
In March 2022, Joseph Desmond was convicted of charges related to the incident. At his sentencing, the judge condemned Desmond's actions.
Not only have you deprived the victim, their family, of a son, a brother, and uncle, but you deprived the people of this city of a person who was dedicated to responding to their need for help and assistance in times of crisis.
The court noted Desmond's violent history, including a prior hate crime, as a factor in determining the sentence.
I can deter you from harming other people by keeping you in prison for the remainder of your life. And that's precisely what I'm going to do.
Desmond was sentenced to 25 years to life in prison. The judge emphasized that this punishment was necessary to ensure public safety and to send a strong message against such actions. On the evening of August 12, 2015, 21-year-old Devin Shane Keyser was driving his Jeep with 4 passengers, including his 18-year-old girlfriend, Courtney Byton Schubert. The group was traveling on the H1 freeway near the Vineyard Boulevard off-ramp in Honolulu, Hawaii. Unfortunately, Keyser had consumed alcohol earlier in the evening. Witnesses later reported seeing the Jeep speeding and weaving through traffic. Tragically, Keyser lost control of the vehicle, and it collided with a guardrail. The crash had devastating consequences. Courtney, a bright and kind young woman with her future ahead of her, lost her life. Another passenger, 22-year-old Joshua Tika, was critically injured and placed on life support, but survived after a long recovery. The other passengers also sustained injuries. Investigators revealed that none of the vehicle's occupants were wearing seat belts, which worsened the impact.
It was not an accident when the defendant decided to drink that night. It was not an accident when he chose to pound beers that night.
Courtney's death left her family and friends heartbroken. She was remembered as a vibrant and caring person who had so much to offer the world. Her cousin, Teresa Schubert, spoke about the immense loss, saying that this tragedy was avoidable.
We recognize that this tragic accident could have been avoided if better choices were made.
In the aftermath, Keyser faced legal charges of negligent homicide. Prosecutors stressed the seriousness of his actions, arguing that drinking and driving is never an accident but a choice. During the trial, Keyser expressed deep remorse for his role in the tragedy. He apologized to Courtney's family, saying,
I want to say sorry to Courtney's family for what I did, the pain and suffering that I put them through. I want to say I'm sorry to my friends.
Despite their grief, Courtney's family showed remarkable compassion. They requested leniency for Keyser, asking the judge to consider probation rather than a lengthy prison sentence. Keyser acknowledged their kindness.
That I very much admire their ability and willingness to be charitable and forgiving.
Teresa Schubert said that she hopes her story will encourage others to make safer choices and protect their loved ones.
Losing our Courtney continues to be a challenge for our family. However, it is our hope that our loss will only help others keep their loved ones alive.
On March 23, 2016, the court reached its decision. Keyser was sentenced to 10 years in prison for negligent homicide. The judge emphasized that the sentence reflected the gravity of the case. While the ruling brought a sense of closure, Courtney's family remained focused on sharing her story to raise awareness about the dangers of drinking and driving. A trial date has been set for Tony Earls, who is charged with murder in the tragic death of Arlene Alvarez. The case dates back to Valentine's Day 2022, when Arlene was riding in the back of her family's car. Earls, attempting to shoot at a man who had just robbed him at a nearby ATM, accidentally struck Arlene with a stray bullet, resulting in her death. Initially, Earls faced charges of aggravated assault, but was released after a Harris County grand jury declined to indict him in 2022. However, following efforts efforts by the Alvarez family to uncover new evidence. Earls was charged with murder in April 2024. He was arrested the following month, and his bond, initially set at $100,000, was later reduced to $75,000. The Alvarez family remains determined in their fight for justice, emphasizing the need for accountability in the case. They have voiced concerns about potential disruptions, particularly the possibility of the special prosecutor being removed when the newly elected Harris County District Attorney takes office. The family has urged the new district attorney to retain the current prosecutor to maintain continuity in the proceedings.
To take away our prosecutor at this moment in time, when Arlene's anniversary is going to be in February and it will hit 3 years since her death, is detrimental to our case. So I'm imploring on Sean Tier to renew our prosecutor's contract so that we can go forward on this murder trial.
Earls is currently out on bond and scheduled to appear in court for a pretrial hearing on January 22, 2025. His trial is set for June 16, 2025. The Alvarez family continues to honor Arlene's memory and seeks justice for her tragic loss, remaining steadfast in their pursuit of accountability. In 2018, former Hamilton County EMT Justin Whaley was involved in a tragic incident near Soddy Daisy, Tennessee. After a night of drinking, he drove the wrong way on Highway 111 and collided head-on with a vehicle driven by James Brumlow, a father of 4. The crash claimed James's life and left his family devastated. At his trial, Whaley expressed deep remorse, acknowledging the pain he caused.
I've spent my whole life helping people, and to know that I took somebody's life and I've got so much pain.
He took full responsibility for his actions.
This isn't a day that goes by that I don't wish that I was the one that died. It would have saved everybody so much pain. I was the one that messed up. I know that. I know that from the beginning. It was all my fault.
During the sentencing hearing, James Brumlow's family shared the emotional toll of losing him.
I have a hard time trying to find happiness, because every time I try to think about my father and all of the great memories that we shared, I have to get past the image of him first.
His son, Ryan, recounted the heartbreaking moment of seeing his father for the last time, a memory that continues to affect him and his brothers deeply.
So not only is the last time that I see my father, was he unrecognizable? It was my younger brothers as well. And none of us will ever get that out of our eyes.
Whaley was sentenced to 9 years in prison for vehicular homicide, with eligibility for parole after serving 30% of his sentence, approximately 2.97 years.
While we're starting at 8 years, enhancing upward 1 year to 9 years to serve in the Department of Corrections a fair sentence for this. The last thing I'll say to the family is this 9-year sentence, if it was 90 years, it wouldn't take away the pain you're feeling.
While the Brumlow family found some relief in seeing Whaley held accountable, they expressed that no sentence could ever fully heal their pain. In 2024, a judge granted Whaley a new trial for the vehicular homicide and DUI charges, citing newly discovered evidence. However, his convictions for reckless homicide and related traffic offenses remained upheld. Despite his appeal efforts, Whaley's bond requests were denied, and he remains incarcerated as legal proceedings continue. Terry Brian Rivera, charged with capital murder in the death of Carlos Fernandez, made his first court appearance in Houston after being apprehended at the U.S.-Mexico border. This tragic case began when Rivera, the ex-boyfriend of Carlos's mother, allegedly approached their apartment and fired a weapon through an open window, fatally wounding Carlos. At the time of the incident, Carlos's mother, Ashley Ross, and her current boyfriend were asleep. They awoke to hear Rivera shouting outside. Witnesses later reported seeing Rivera flee the scene in a pickup truck. Following the incident, Rivera allegedly called Ashley from a blocked number before going into hiding. He remained on the run for a week before being arrested while attempting to cross the border. The arrest brought a sense of relief to Carlos's grieving family, who had just laid him to rest. They described the days following her son's death as emotionally overwhelming, but expressed gratitude for Rivera's capture, saying it brought some peace of mind.
We're just all happy that, and relieved that he was caught. And, also his mom, she had a part of it. And, it just brought us all a peace of mind.
Carlos was remembered as a loving and protective older brother, and investigators believe he tried to shield his two younger sisters during the tragic event.
I read probable cause. The judge addressed his bond because he's accused of killing a child between the ages of 10 and 15. That particular capital murder provision does not allow for the death penalty, which means we cannot hold him at no bond.
In court, the judge set Rivera's bond at $2 million. Due to state laws, Rivera is not eligible for the death penalty, but could face life imprisonment without parole if convicted. Prosecutors noted that while a bond was set, they do not expect Rivera to be able to post it. The case of Alexis Avila unfolded on a cold January evening in Hobbs, New Mexico. Behind a shopping plaza, 3 individuals searching through a dumpster came across a tightly wrapped black trash bag. Inside, they found a boy, barely alive, suffering from severe cold exposure. The boy had been left there for nearly 6 hours, but against all odds, he survived. The group immediately contacted emergency services, and the boy was rushed to the hospital, where doctors confirmed that his condition was critical but treatable. His survival was described as nothing short of a miracle.
To toss one's own child into a dumpster like trash is something that it is an unforgivable event by any mother. Your child, I do agree, was very vulnerable, but for the grace of God and the happenstance of the 3 dumpster divers that found your child, we certainly would be here sentence you on a murder case as opposed to where you are. It's a miracle that in the cold weather of that night that your child survived. I do find that leaving the child in the dumpster and having hours to think about what you did indicates that it was a crime that you had an opportunity to correct after you thought about what you had done, but you did nothing. The resulting harm to your child, yes, I agree, there was a high probability of death, almost certain death. The impact that we heard throughout the trial about the problems with breathing, the problems with your child's organs, these are serious, serious things. And but for the wonders of modern medicine, your child would be dead. And that's not to mention the psychological effect that this has undoubtedly given a situation where your child's going to have to deal with it for the rest of his life. When thinking about your case, I think over and over again of the fact that there's no doubt that we'd be looking at a murder case, but for luck. So you're very fortunate that those dumpster divers came along. Because there's no question that but for them, your child, who was thrown alive in the middle of a cold afternoon, would be out at the Hobbs landfill dead.
Surveillance footage quickly led authorities to 18-year-old Alexis Avila.
He's still got his umbilical cord, he's freezing cold, and he's very, he's drained, he's very, very, very weak.
The video showed her driving up to the dumpster, stepping out of the car, and disposing of the bag before leaving the scene.
Yes, ma'am. Okay. Why did you go to the hospital on Tuesday, January 4th?
I was having back pain.
Could you describe what that was like?
Kind of like a sharp pain to my muscles, kind of like a sharp twist to my muscles and bones.
What part of your back?
My lower back, lower hip.
Okay. So, is this pain that you were familiar with, or was it unusual?
No, I'm very familiar with it.
Why?
It happens frequently, multiple times out of the week. It's nothing out of the ordinary.
Okay. What Do you know what the cause is?
The accident. When I got in the accident, I got a referral to Odessa, and I got X-rays done, MRIs, and the doctor said that I had a crack in my bones on my L4 and my L5, and there was fluid in there.
What did you tell the professionals at the hospital?
The same that I just told you. I had lower back pain, and that I got in a car accident.
Okay. And what did they do?
They didn't do much when they did see me. I believe only one doctor touched me, and the other, he just leaned over the counter and just spoke to me.
Did you get any prescriptions at that time?
Yes, ma'am.
And what happened?
They just sent me home and told me to take it when needed.
Was that for the pain or was it for something else?
It was for the pain.
Okay. So, did you take it?
Yes, ma'am.
What effect did it have on you?
Not much. Not a lot of medication helps my back pain. So it helped for maybe 10 minutes, if that, and the rest it didn't.
So on January 6th, you go to see another doctor. Okay, you have to say yes.
Yes.
Oh, sorry. All right. So January 6th, you go to see another doctor. What happened at that visit?
I explained to them my pain as well, and they told me to pee in a cup.
Okay. And did you do that?
Yes, ma'am.
Okay. And then what happened?
And then shortly after, one of the doctors comes, or the doctor that I did see, she came into the room and told me I was pregnant.
How did she deliver that news to you?
When she came in, she kind of put her hand on my knee or my leg, which I don't really like people touching me, so I wasn't comfortable with. And then she told me that I was pregnant.
When she told you you were pregnant, what did you think at the time?
I'm not sure. I kind of blacked out.
Why did you black out?
I was in shock, I guess.
What else did she tell you?
Oh, I don't remember.
When questioned, she claimed she had not known she was pregnant until the day before and had acted out of fear and panic.
Yes. Now we're going to talk about January the 7th, okay? Something happened that day that brought us to this case today, right? So we'll talk about that day. Before we talk about that though, so when you gathered with your family on the 6th, did you tell anybody what the doctor told you?
No, ma'am.
Why didn't you tell them?
I was still trying to process it myself.
What did that look like for you, processing it?
I wouldn't be able to tell you.
Were you at that moment aware that you were going to birth a baby the next day?
No, absolutely not.
So the next day, January 7th, what did you do that morning?
Nothing much. I believe that whole day I was in bed.
Why were you in bed?
For my back pain.
What did that feel like as at the 7th?
The same, like pulling muscles in my back, like sharp pain.
What about your parents on the 7th? What were they doing that morning?
They were at work.
Both your mom and dad went to work?
Yes, ma'am.
Okay. So you're at home. Was there anybody else?
No, ma'am.
So while you're home, what do you do other than lay in bed?
That's about it. A couple of times I would get up to use the restroom, or try to, but I would just go back to bed.
Okay, when you say you would get up to try to use the restroom, what was going on with you at that time?
I just felt like I really needed to go to the restroom. I felt really constipated, which is nothing unusual.
So you felt constipation before?
Yes.
So you know what that felt like? And you believe that's what was going on?
Yes, ma'am.
Did you do anything to resolve what felt like constipation?
Not during the morning. There was a time, I wouldn't be able to tell you the time, where my dad did take me some kind of pill. I don't know what it was. It was some kind of constipation pill. And I took that and I went right back to sleep.
Okay. So you go right back to sleep, and then what's the next thing that happened?
I woke up and I used the restroom. Well, my dad was actually there when I woke up after taking the pill. He was only there for a short amount of time. He did probably his insulin or something, used the restroom and left. And then when he left when he got out the restroom to leave, that's when I went into the restroom.
Okay. So this time around when you went to the restroom, what happened?
I delivered a baby.
How did that happen?
I don't remember. I just remember sitting there. And then the baby was on the toilet or on the floor. I don't remember.
You don't remember if it was in the toilet bowl or on the floor? So, what were you thinking in that moment?
I was in shock. Like, how could this happen?
So what did you do?
I don't remember.
What was the next thing that you remember?
I think when me and my mom went to the police station to go to the hospital.
She explained that she had experienced sudden pain, gone to the bathroom, and unexpectedly delivered the boy. Unsure of what to do, she placed him in a bag and left him behind. Her arrest made headlines, and public reaction was swift. Prosecutors charged her with attempted first-degree murder and child abuse, resulting in great bodily harm. During the trial, medical experts testified about the boy's condition, highlighting the serious risks he faced due to prolonged exposure. The prosecution argued that Avila's actions showed intent, as she had multiple opportunities to seek help but chose not to. The defense, however, presented a different perspective. They pointed out that Avila was only 18 and had been dealing with undiagnosed bipolar disorder. Her attorneys argued that the combination of her age, mental health struggles, and lack of support led her to make a terrible decision in a moment of panic. They also emphasized that she had no prior criminal record and had complied with all court requirements during the proceedings.
I sent you to 18 years followed by 2 years parole. I'm going to suspend 2 years. So you do 16 years in the Department of Corrections with credit for time served. You have 475 days pre-sentence confinement credit. While in the Department of Corrections, you will participate in complete course of cognitive behavior therapy, which will deal with some of your psychological problems. You'll complete a course on parenting skills, and you will participate in any vocational training or college classes during that period of time. I impose a mandatory $5 domestic violence treatment fee, $75 Crime Victims Reparation Act fee, $100 DNA fee. I do find that this is a serious violent offense, which means that your day's credit, the most you could get for good time would be 4 days per month.
The judge sentenced Alexis Avila to 18 years in prison for child abuse, resulting in great bodily harm, but suspended 2 years, reducing her term to 16 years. While acknowledging the seriousness of the crime, he considered her young age and mental health struggles in his decision. Avila was also required to complete therapy, parenting courses, and vocational training. Fines were imposed, and her eligibility for early release was restricted due to the classification of the offense. The judge emphasized that beyond the legal punishment, Avila would carry lifelong guilt, while her son would bear the emotional impact of the incident forever. safer. However, in October 2023, the New Mexico Court of Appeals granted Alexis Avila's release while her appeal was pending, citing substantial legal questions that could potentially lead to a reversal or a new trial. The court also determined that she was not a flight risk and posed no threat to the community. As a result, she was released under the same pretrial conditions. She is prohibited from possessing weapons, consuming alcohol, or contacting the victim and witnesses. She must remain within the county, avoid violating any laws, and stay in communication with her attorney. Additionally, she can only move within designated areas of her residence. Tracy Nix, a grandmother from Wauchula, Florida, found herself at the center of a heartbreaking legal case following the tragic death of her granddaughter, Uriel Schock. The incident was made even more devastating by the fact that it occurred less than a year after another grandson, Ezra. In December 2021, Tracy was babysitting Ezra when he wandered outside and drowned in a nearby pond. Authorities investigated, but ruled it an accident and no charges were filed. Despite the loss, she continued to be involved in caring for her granddaughters and grandsons. On November 1st, 2022, Tracy agreed to watch Uriel while her daughter, Kayla Nix, attended a hair appointment. She took her granddaughter to lunch with friends, then drove home, parked the car, and went inside, forgetting that Uriel was still strapped in the back seat. With the Florida heat reaching the 90s that afternoon, the car quickly became dangerously hot. Hours later, Tracy realized the girl was still inside, but by then, it was too late. Uriel had succumbed to heat exposure. Authorities launched an investigation, and unlike Ezra's case, this time, Tracy faced criminal charges. She was charged with aggravated manslaughter of a child and leaving a child unattended in a vehicle. The prosecution argued that her negligence led to Uriel's death, while the defense maintained it was a tragic mistake. Her attorneys suggested that medication, such as Ambien, may have affected her memory, though this was not a major focus in court. During the trial, Kayla gave emotional testimony about the moment she learned of her daughter's death. A police officer arrived at her home and delivered the devastating news. Later, she had to identify Uriel's body at the hospital, an experience she described as unbearable. She added that her mother willingly agreed to look after her daughter and thought that she could trust her mother with her daughter.
So that day, November 1st of 2022, what were you doing that day, ma'am?
My husband and I own a small business in Wauchula, A1 Safari Glass. I have always been a full-time mom first before my career, and so every one of my children actually go to work with me every day that I attend work, unless they're sick.
And so did Yuri go to work with you that day?
Yes, my daughter went to work with me that day, and typically my routine was to leave at lunch so that I could get the baby home, get them fed, and then let them nap, let her nap in, her own room stuff.
And I'm sorry, you called Uriel Yuri?
Yes.
Okay. And so, well, did you follow that plan that day, or was it different?
Well, that day began out most similarly to all my other days. Get up in the morning. My daughter and I went to my office. We began the work day. I remembered I had a hair appointment, and I reached out to my mother at that point and asked if she was busy.
Let me ask you this. How did you reach out to her?
Via text.
Okay. And were you able to get a hold of your mom?
Yes, I was.
And what was the nature of that conversation you had with her?
I don't remember specifically if we actually had a phone call or if it was exclusively text message, but the question was, I have a hair appointment at this certain location, and she responded that she had a lunch with a few of her friends. Those friends are people that I've grown up with my entire life. So I certainly felt comfortable in that circumstance, allowing my daughter to go to the restaurant with my mom. That restaurant was pretty much in the same block as the hair salon that I went to. So I knew I would be nearby.
Excellent. And how long was she going to take care of her?
From pre-lunch, whenever she picked her up to go to the lunch, I probably left 20 minutes or so before she arrived at my office to pick up my daughter. And then the plan was for my husband to stop back by their house at the end of the day when he leaves our business, pick up our daughter, and come home.
And the end of the day, what's the end of the day for your business typically?
4:30 to 5.
And he was going to go where to pick her up?
To my parents' house on Kaiser Road to pick her up.
So, you went to your hair appointment?
I did.
And from the time
that you completed your hair appointment, when was the next time you heard anything about your doctor?
I finished my hair appointment pretty soon. It was not a long appointment. I'd say it was about 75 minutes. And at that point, I went home to begin dinner and move the laundry and just start an evening routine that I would typically do at home with my child. So I went home expecting my husband to pick up my daughter from my parents' house.
Okay.
And the next time that I heard another thing about her was Officer David Drake outside of my home in Wauchula.
And we'll get there in a moment, if you don't mind. So between the time that you saw the officer and the time that you left your hair appointment, did you have any communications with your mother?
I do not believe that I did.
Okay. Now, let me back up for one moment. I apologize. Does your mom have everything she needs to take care of Yuri whenever she takes her, or do you have to supply those to her?
Absolutely. I always pack her bag for the office, so she comes every day that we leave the house. She does come with a bag full of multiple supplies items. But then at her house, my sister had children, and they actually lived in her home for a while. So there was a bedroom dedicated to just whatever grandchild was at the house at that time. And so she actually has a crib there, changing table, no, not a changing table, just simply a dresser with diapers and clothing and all of the things.
And then on that day, did you supply your mom with anything to help take care of Yuri?
Absolutely, yes. I sent her with a standard bag that I would pack for myself. So she would have multiple clothes, diapers, wipes, creams, food.
And does she have a car seat in her vehicle, or does one have to be put in there?
One has to be put in there.
Okay. So when she picked up Yuri that day, she would have also had to put the car seat in?
Absolutely. She typically put her seat in behind the driver's seat.
Okay. So let's go to the point where the officer showed up at your door. Was that, do you remember what time of day that was approximately?
My guess would be 2:30, 3 o'clock. I was not on any sort of a regimented schedule at that point, so it would have been sometime between probably 3.
Okay. Now this was a while ago?
Absolutely, it was 2 years ago.
Okay. Whenever time that might have been, why did the officer show up at your door?
He showed up at my door to notify me that my child was deceased. That his words were, "Your baby is dead. Your daughter is dead. Your child is deceased, and we need you to come with us."
Okay.
I have to identify the body.
Okay. Where did you go, ma'am?
I got in the vehicle with the sheriff that came to get me. They did not believe that I should be driving, which I agree. And he took me to the Florida Advent Hospital in Wauchula.
Okay. And you said you had to identify Yuri?
Yes.
And you saw her?
I was not with my husband in that moment, and so as soon as we found each other in that parking lot, which was sheer envy, then we went in together to look at our daughter and identify her daughter.
Meanwhile, Tracy's friends testified that she was a loving grandmother who would never intentionally harm her granddaughters and grandsons.
I was relieved to hear that there was going to be accountability and ownership and a conclusion to this part of this story. One of the things that we have struggled with through this whole case has been the exclusion of my other story, which is my son that drowned in her care. And so for us, this is a win for Yuri. But I have a son named Ezra, and he has not been spoken of. And he died in her care. And I don't have any accountability or any answers for that. And I continue to look for those answers to what happened in that case and why that case was not worthy of prosecution at that time. So we're going to be going back in with the state and having a few more conversations to see. But in this moment, we are relieved. The daughter and me had a very hard time with her being taken, and I ended up stepping aside for that moment. And it isn't something that I would ever call a win for me. It is a win for justice for my daughter.
One of the most debated aspects of the trial was the exclusion of Ezra's drowning. The judge ruled that it was not relevant to the case, frustrating Kayla, who believed both incidents should have been considered together.
In the Circuit Court of the 10th Judicial Circuit of Florida, in and for Hardee County, State of Florida versus Tracy Howard Nix, case number CF 22-000-A000-XXW. Verdict form. We, the jury, find as follows as to count 1 of the charge. The defendant, Tracy Howard Nix, is not guilty. We, the jury, find as follows as to count 2 of the charge. The defendant, Tracy Howard Nix, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
In January 2025, the jury reached a verdict. Tracy was found not guilty of aggravated manslaughter, but guilty of leaving a child unattended in a vehicle, a lesser charge. She was taken into custody immediately and now faces up to 8 years in prison, with sentencing scheduled for April 3rd, 2025. Her attorney has indicated plans to appeal, possibly citing memory impairment as a factor. Phil Spector, a renowned music producer, became the focus of a highly publicized trial following the death of actress Lana Clarkson. The case, filled with conflicting testimonies and forensic evidence, eventually led to his conviction. On the night of their meeting at the House of Blues, Clarkson left with Spector for his Alhambra mansion. Hours later, a shot was heard, and Clarkson was found deceased in the foyer with a gunshot wound. A revolver was near her body, and Spector's chauffeur, Adriano de Souza, testified that Spector had emerged from the house holding a gun, stating, "I think I killed somebody." Despite this, Spector's defense claimed Clarkson had taken her own life, arguing that she was depressed about her struggling career. Investigators quickly challenged this theory, finding no history of suicide thoughts in Clarkson's medical records. Friends and family testified that she had upcoming projects and showed no signs of despair. The prosecution built its case on Spector's history of violence, presenting multiple women who described instances where he had threatened them with firearms. Their testimonies painted a pattern of intimidation, strengthening the argument that Clarkson had not died by her own hand, but was another victim of Spector's volatile behavior. The defense sought to establish Clarkson's alleged depression through witnesses Jennifer Hayes and Pumpkin Pie, both claiming to be close friends who insisted she was unhappy and had spoken of feeling hopeless. However, the prosecution systematically dismantled these claims.
So that wasn't going to work. They couldn't show that she had suicidal ideation. They couldn't show that she had prior suicide attempts. They couldn't show that she had been diagnosed with major depressive disorder. They couldn't show any of that stuff about Lana. All they could show is that she was a normal human being. So what do? They turned to Jennifer Hayes and Pumpkin Pie. Y'all have been waiting for me to talk about that, hadn't you? Jennifer Hayes and Pumpkin Pie. What did Jennifer Hayes say? Jennifer Hayes said, Lana Clarkson and me and Pumpkin Pie were the Three Musketeers. Inseparable sisters. We were each other's confidants. We were each other's go-to gals. We were inseparable. We were connected at the hip. We were the Three Musketeers, according to Jennifer Hayes. I loved Lana. I knew everything about Lana, and I knew the real Lana, which is real convenient, by the way. Oh, all you people, everybody else, all the evidence that says that she was a happy person, oh, that was just the game-face Lana. I knew the real Lana. I got down into the dirt with her. I knew the real Lana Clarkson. Really? Did you? One of the first things you said on cross-examination, actually it was direct examination, I think it was a faux pas, I think she wished she could have taken it back. She said, I'm Pie's memory. I, Jennifer Hayes, am Pie's memory. Pie has such a poor memory. Pumpkin Pie can't remember her name if I don't give it to her. She has such a poor memory that I'm actually her memory. What else do we know? We know that Tawny Tyndall, as she is wont to do, interviewed her. But amazingly, there's no recording of that interview. And she interviewed her with another person. She interviewed Jennifer Hayes right alongside another person. Who could that person be? Oh yeah, Pumpkin Pie. The three of them sat and chatted together, and what do you think they did? Do you think Pumpkin Pie might have helped Jennifer Hayes a little bit get her story straight? We're going to get to Pumpkin Pie in a second, and her motivations in this trial in just a second. But do you think that their testimony sounded just alike enough that it's suggestive that they might have gotten their story straight? One thing's for sure, you, folks, will never know. You'll never know. Because Tawny Tyndall and the defense made sure that those conversations were never recorded. So you'll never know. You have to ask yourself, whose testimony were you listening to when Jennifer Hayes testified? Was it hers? Was it Pumpkin Pie's? Roger Rosen even talked to Jennifer Hayes at one point. That wasn't recorded either. Whose testimony were you really listening to? And then we find out that Jennifer Hayes knows about the cottage. This is the inseparable sister, the person that is closer to her than anybody else. They trade confidences and intimacies. They talk constantly. They know each other's good moods, bad moods. I know the good moods, bad moods, and I, Jennifer Hayes, know the real Lana Clarkson. Really, how long has she lived in the cottage? Oh, as long as I've known her. Absolutely, I've known her 8-9 years. She's lived there the whole time. Oops. Guess she didn't get that one straight during her conversation with Pumpkin Pie. Lana Clarkson lived in the cottage for about 2 years, a little over 2 years. Jennifer Hayes doesn't even know where Lana Clarkson lived. I'm not saying they didn't know each other. I'm saying you have to question whether or not they knew each other in the way that Jennifer Hayes said they knew each other. Keep in mind, she's got no corroboration whatsoever about their relationship, except one person. Pumpkin Pie. Interestingly enough, you'll have available to you, and I don't suggest you do this, it takes a long time. Actually, I suggest you do it. What the heck? You got nothing but time anyway, right? We presented you with phone records. Cell phone records from Lana Clarkson, cell phone records from Jennifer Hayes. Not one phone call in the last 3 months of Lana Clarkson's life. Not one call received, not one call made. Well, you know what? We're in an email society. They don't talk on the phone. They get together all the time and share their intimacies in email. We know what a prolific emailer Lana Clarkson was, right? So it must have been email. We'll give Jennifer a break. Oops. Not one email. Not one email in evidence that you have between Lana Clarkson and Jennifer Hayes. Whose testimony were you really listening to? Hers or Pumpkin Pie's?
Phone and email records showed Clarkson had not contacted Hayes in months, contradicting her assertion of a deep and constant friendship. Hayes also misstated basic facts about Clarkson's life, such as how long she had lived in her residence, further weakening her credibility. Pumpkin Pie's testimony faced similar scrutiny. Initially, she had told detectives that Clarkson was not suicidal, but her story changed after learning that Spector's associates had connections to the nightclub scene she was involved in. The prosecution pointed out her shifting narrative and highlighted her active pursuit of media attention after Clarkson's death.
And then we have Pumpkin Pie, who without question has chased the limelight from the day Lana Clarkson died. With the memorials that she went to, having her own memorial at some club that she was promoting. She was so devastated, by the way, that she got up that next Tuesday. Lana Clarkson lost her life on Monday. She got up on Tuesday and promoted another club. Oh, I had to be dragged out of bed, and I was dragged out of, the grocery store, and I collapsed, et cetera, et cetera. Oh, please. She was promoting a club the next day. I'm not saying that she wasn't hurt by Lana's death. I'm not being insensitive to her hurt. I'm saying, can you really believe this sob story that Pumpkin Pie was trying to sell you? Let's think about this. You have to test the character and quality of her testimony on this witness stand. Because, folks, the reality is, if it didn't come through that microphone, or it's not presented to you physically, it ain't in evidence. All right? What comes through that microphone is evidence. So you can test how Pumpkin Pie acted and reacted. You can test the character and quality of her testimony just by how she acted on the stand. How was she dressed? Did she come dressed appropriately? Or did she look like she was looking for attention? Everybody thought about that. Of course, the defense got her cleaned up the next time she was called to the stand. Or somebody got her cleaned up the next time she was called to the stand. Did she really look like someone who had just lost her best friend and is in the trial of her best friend's death as she tries to give over the truth about her friend? Or did she look like she was trying to draw attention to herself, just with her appearance, before she even started talking?
She had hosted events, given interviews, and even sought a book deal. Her behavior in court, waving and smiling at spectators, was also cited as evidence that she was more interested in publicity than in seeking justice for her supposed best friend. One crucial point the prosecution emphasized was Clarkson's purse, which was still on her shoulder when she was found. This detail suggested she had been preparing to leave rather than taking her own life. The defense attempted to counter this by having Pumpkin Pie claim Clarkson always carried her purse that way.
One thing they can't get over, one thing that will never, ever make any sense, is that Lana Clarkson killed herself while she had her purse on her shoulder. Is having her purse on her shoulder more consistent with committing suicide, or is it more consistent with saying, hell, I'm ready to leave, I'm ready to go home? They can't get past that. They cannot ever get past that because it makes no sense, and they know it. So what do? Here's the Hail Mary. You know what? Pumpkin Pie's like Mikey. Remember those Life commercials, the Life cereal commercials? Mikey? Give it to Pumpkin Pie. She'll say anything. Remember Mikey? He'll eat anything. You know what? We're screwed on this purse issue. We can't get by that. The purse is the purse is the purse. It's on her shoulder. How do we explain that? Oh, well, I got an idea. Just give it to Pie. She'll say anything. Have hers testify that Lana constantly had her purse on her shoulder. Every single time she saw her, her purse was on her shoulder. So Pumpkin Pie comes to court and she says exactly that. I swear to tell the truth, the whole truth, nothing but the truth, so help me God. Lana always had her purse on her shoulder. And she's out of here. Really. Except for all those photographs that they forgot that they introduced at the parties and at the beach and in Hawaii and in Jamaica and at such and such table and at the Jeff Franklin park. And guess what? Guess what's missing? Oh yeah. Didn't think about that, did you? Not one photograph has her with her purse in it. Not one photograph has Lana with her purse in it.
The first trial in 2007 ended in a mistrial when the jury could not reach a unanimous decision.
The defendant is sentenced to the term required by law, 15 years to life, on his conviction for second-degree murder for the enhancement pursuant to 12022.5a. The personal use of the firearm. The court selects the presumptive midterm of 4 years for a total of 19 years to life. Credits would be from April 13th. Wendy, can you give me a quick calculation? Plus the one that for a total of 47? Actual. All right, 47 days actual credit pursuant to 2933. I believe. Let me double check. The defendant is not entitled to any good time, work time credits pursuant to 2933.2 because of the conviction for second-degree murder.
The retrial in 2008, however, led to Spector's conviction in 2009 for second-degree murder, sentencing him to 19 years to life. His appeals were denied, and he remained in prison until his death in 2021. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.